Good afternoon, students. In this session of environmental law, we are going to revise the further legal provisions of the Environmental Protection Act. So, in my previous session, I have already taken up the revision of the origin, how it all happened. We have discussed about that how eventually in the Stockholm conference, it's Stockholm. That all the principles that were 26 principles that was being decided in Stockholm conference, that was being taken into conformity. And when you see Environmental Protection Act, how it came into being, we have seen that it has been given under Article 253 of the Indian Constitution. It came into existence, and in conformity with the principles that was being decided in the Stockholm conference. And when we talk about the aims, objective, characteristics that we have discussed in our previous session, we have dealt with the definition part. We have dealt with the powers and functions of the central government. Section 3, to take measures. Section 4, to appoint the officers, and to delegate them with such functions which is necessary for the enforcement of to fulfill their duties and responsibilities. And then we have Section 5 we have discussed, which is power to give direction. 6, powers to power to make rules in order to regulate environmental pollution. So we have seen how Section 6 and with 25, Section 25, the central government has used this power, and they have formulated environmental protection rules of 1986. 23, Section 23 is power to delegate such functions. Section 10, entry and inspection. Now 10 and 11 have to be read together. So entry and inspection in order to take samples, and procedures which are very necessary that needs to be followed. Then only the sample analysis will be taken, the analysis of the sample, the results of which the report will be taken into consideration as evidence in any legal proceeding. So today we'll start off with the power of jurisdiction and other law. So when we talk about Section 22, it talks about the bar of jurisdiction. So when we say bar of jurisdiction, we have read that no civil court have the jurisdiction to entertain any suit or proceeding with respect to anything that has been done. Any action taken or order or issue direction that is being issued by the central government or any authority or any officer in pursuance of any power that is being conferred on them for their function under this act. So no civil court can do so. Now, when we talk about Section 24, we have dealt with it, that it talks about the effect of other laws. Now, very, very important part for you to understand, then whenever we talk about Section 24, we have to understand that when it talks about the effect of other laws, we know that it has created a lot of controversy, because when we look at the implication of Section 24, we have seen that the provisions of the other legislation, because Section 24 talks about that is subject to the provision of subsection 2. The provisions of this act and rules or orders made under their shall have effect notwithstanding anything inconsistent therewith contained in any enactment other than this act, that the provisions of this act enjoy predominance over other subjects. However, subsection 2 of Section 24 provides that where any act or omission constitute any offence punishable under this act and also under any other act, then the offender would be liable to be punished under the other act, not under this act. So now there is a problem. Then you need to always remember, whenever we are talking about Section 24, the implication of the other laws. So whenever you talk about the provisions of other legislation, they enjoy predominance over Environmental Protection Act with regard to the punishment of commission or omission of an act which constitute an offence under environmental protection law and any other law. So you know that the offender will be punished if so found guilty under the other laws, not under environmental protection law. And the act, that's how it makes this act a toothless tiger. So when we see that, so that there is, the act loses the significance and the logic in the view of, when you see that the if you're found to be guilty in this act, environmental protection and other laws, then you will be punished by the other, then it loses its significance. So you have to talk about the implication of it also. And when next in line is environmental. So when we talk about, I have told you about 10 and 11, power of entry, inspection and collection of sample and all. So all these, they work together. So when you talk about uh, section 12, so 11 talks about the procedure that needs to be followed. So section 12, we have learned that how it empowers the central government to establish establish and recognize state laboratories, central laboratories where the test can happen. So they can establish environmental laboratories by notification in the official gazette, and empowers the central government to appoint government analysts. And when you talk about the government analysts, so when you talk about section 13, section 12, 13, 14, and 20, all of them have to be read in together. So when you say that they establish the government laboratories, then the role of the government analyst becomes very important. So analysts by notification they appoint, and for the purpose of analysis of samples which has been taken, samples of air, water, soil, or other substances, and which has been sent, needs to be sent to the laboratories. And if you look at section 14, it provides that the report of the government analyst may be used as an important evidence for the fact stated therein in any proceeding under this act. And when we look at section 20, it talks about the information reports and return, which says that the central government, in relation to the function that has been given to them under this act, from time to time may require any person, officer, state government, or any other authority to furnish them with report, to prescribe any authority or officer any report, return, statistic, account, or other information. And such person, officer, state government, or authority shall be bound to do so. So they are under binding duty to provide them with such information, reports, and return whenever the central government would ask so. So all of this, it plays a very important role whenever we talk about evidence, whenever we talk about the authority, whenever we talk about inquiry, investigation. So the next in line is offenses. So when we talk about offenses, so here section 7, let's do section 7 and 8 first. So it talks about section 7 says that it prohibits the discharge of environmental pollutants, in any discharge of any pollutant which is in excess of the prescribed standards. So you know that the central government has power to prescribe standards, make rules, regulate them. So prohibition of emission or discharge of environmental pollution, it contains an injunction and prohibits any person carrying on any industry, operation, or process, and prohibiting him, restricting that person from allowing emission or discharge of environmental pollutant in excess of the standard that is being set up by themselves, the central government. Okay, and then we talk about section 8. Section 8 is, remember the definition part, handling of hazardous substance, the two important definitions, handling and hazardous substance. So section 8 is related to persons whosoever is handling hazardous substances, that they have to comply with the procedural standard that is being, procedure standards which are important to ensure the safeguard against any kind of problem, environmental problem. So no person, this section says that no person shall handle or cause to be handled any hazardous substance except in accordance with the procedure and after complying with the safeguards as may be prescribed. So it's the power of the central government that they exercise under their power, that they issued, prescribed measures, prescribed standards, ways in which the people who are handling these hazardous substances have to take care, have to handle these hazardous substances, their activities in accordance with the procedure which has been established, and follow up, put in all the standards which has been prescribed by the government. And if they don't do so, it will be amount to an offense. Now, we next will move on to section 16 and 17, where it is mentioned that what happens when the offenses are committed by the companies. And next is when the offenses are committed by the government departments. So when we have already dealt with this thing that when the offenses are being committed by the companies, so here the company will be taken into consideration that that under this act, if from see the responsibilities of the central government to regulate the activities, to see that if an offense has been committed by a company, then whosoever the person whosoever was at the commission of the offense was directly in charge or was responsible uh, for the activities of the company shall be held responsible. And this person uh, is to be held responsible for the company's conduct of business, and shall be deemed to be guilty of the offense, and shall be liable to be proceeded against and punished accordingly. So it would be the person who will be taking care of the company, who will be in charge of the company at the very time when the offense was committed, shall be held responsible, deemed responsible. Now, but the only exception that is available to the person is that if he is able to prove that the offense was committed without his knowledge, or he exercised all the due diligence in order to prevent the offense, then he'll be able to get away from the charges, the responsibility that has been leveled against him. And if under this act any offense is committed by a company and it is proved that offense is committed with the consent of this, or the neglect of any of the director, manager, secretary, or any officer of the company, then all these people will be held liable to be prosecuted. So the manager, the director, the secretary, or other officer shall be deemed to be guilty of that offense and shall be liable to be proceeded against and punished accordingly. Okay, so you need to remember that the exception that has been given, and if it has been shown that whatever offense has been committed is committed with the knowledge, with the consent, or it is attributable that through their conduct that there was negligence on their part, then these people will be held responsible, whosoever was in charge. Okay, like director, manager, secretary, and all. Now, if similarly, if the offense is been committed by the governmental department, so we have section 17, which talks about what if the offense under this act is committed by the Department of Government. Then in this case, similarly, here the head of the person who was taking, who was in charge, here the head of the department will be held liable, and he will be deemed guilty of the offense and shall be proceeded against and punished accordingly. Again, the exception is there if the head is able to prove that he whatever happened, the offense happened without his knowledge, or he exercised. So there are two conditions: that he is able to prove that whatever happened is happened without his knowledge, or he is able to prove that he applied all the due, exercised all the due diligence to prevent the offense from the commission of such offense. And but again, the similarity of the same section, which if you have read in 16, that so if he's able to prove that without his consent this thing happened or due diligence was applied, then he'll be saved. But if the offense has been committed by department and it is provided that the offense has been committed with the consent, or it is attributable that neglect was there on the part of the officer other than the head of the department, such officer shall be deemed to be guilty of that offense and shall be liable to be proceeded against and punished accordingly. So here, if the government department commits an offense under this act, and it is proved that the offense has been committed with the consent or attributable that there is neglect on the part of any officer other than the head of the department, then such officer shall be punished and proceeded against and punished accordingly. So now next is cognizance offense. So when we talk about a cognizance of offense, section 19. So now here you have to remember that when we talk about section 19, we have to understand that the central government, so no court, it's a citizen suit provision also, it says that no court can take cognizance of any offense under this act, except if there was a complaint that is being made, you know, uh, by their central government or authority or any officer or authority, who's authorized in its behalf, or a person who has given a notice for not less than 60 days and in the prescribed manner, and he must make it sure that he had every intention of making a complaint, and then to the central government or authority or the officer authorized. So the complaint has to be made by this, any individual can make this complaint, and the complaint should be the information, or whenever he's making such complaint, it a notice has to be notice period that is being given, it should not be less than 60 days, and after that the cognizance will be taken up. So the next important thing that you need to know after this is that when we talk about the penalty provision. So when we talk about the penalty provision, we know that it's section 15. It talks about that whosoever it fails to comply with the rules, fails to comply or contravenes with the act, rules, orders, directions which are made under this act, needs to, this issued, orders, directions which are issued under it, shall be, with respect to contravention, will be punishable for a term which may extend to 5 years, or fine which may extend to 1 lakh rupee, or both. So 5 years and 1 lakh rupee both. And if the failure, the contravention continues, then additional fine will be charged, which may extend to 5,000 rupees every day, during which such failure or contravention continues. After the conviction of such failure conviction, contravention, okay. And if it continues for a period of 1 year after the date of conviction, if the offender shall be punishable with a term which may extend to 7 years. So when we talk about the penalty provision and we talk about the citizens suit provision, as section 19 clearly says that it says that any person that has the right to move the court complaining of an offense under this act, provided that person has given notice of not less than 60 days to the government, or showing his intention to file a complaint. And after showing a notice to the central government, the person can move ahead with the complaint. And after giving 60 days a notice to the government, a citizen may prosecute the offender by filing a complaint to a magistrate. And the notice is intended is just to it's the intention behind giving the 60 days period, which is also a loophole that we have discussed in our classes, is just to alert the government of the offense, and that it may take appropriate remedial measures, so giving them opportunity so that they can take appropriate measure. And we have also seen that with this provision, the citizenship provision expands the concept of locus standi in environmental prosecution. And then when we talk about the legal infirmities which is there in Environmental Protection Act, it suffers from various drawbacks. So because when we talk about the concept of environmental impact assessment, it's not mentioned. Environmental audit, there are two important concepts of environmental jurisdiction, but there is no reference to even concept of sustainable development, which essentially underlines the Environmental Protection Act. And and the other problems that we see in here is that the essential features of precautionary principles, the polluter pays, do not find any place in the act. And also it provides for the liability of the polluter to bear the cost of polluters pollution, despite the fact that the act is an umbrella legislation. Yet, in order to, umbrella legislation when it comes to protection of environment, but it does not provide for any establishment of environmental code. So when we look at the environmental protection law, environmental protection act, and then essentially the important features that you need to remember is the power, how immensely powerful central government is under this act. And then the lacunas in the legal provision that they have dealt with a number of case laws that needs to be done. So what all provisions we have tried revising are the important ones, but they are to be read along with the other preceding and succeeding provisions of the act which is given. So if we talk about uh, the overall conclusion, so Environmental Protection Act is is considered as a comprehensive umbrella act, but it still requires review, still requires changes, because in the light of new problems, diseases, excess of population growth, they look at the current situation. We know that it has it has lacunas like weak citizen suit provision, um, liability, fixing the liability of the corporate officials. And, despite various enactments and administrative machineries to implement the environmental policy, by how the problem of environmental pollution still remains a great, concern for all of us. So it is very important that legislative and judicial pronouncement should be, uh, taken into effective manner, and their implementation happens, and the enforcement mechanism needs to be strengthened, and the whole concept of environmental legislation should be reviewed and amendments should be introduced whenever necessary in order to uh, practically protect the environment from further degradation.